used to experiencing anyway. So we'll go ahead and start this meeting with roll call. Judy?
Senator Cooper. Here. Senator French.
Here.
Senator Cole.
Present.
Senator Koss.
Here.
Chairman Nazarkot.
Here. All right, so for members of the public and those in the room, there is that sound of static in there. We can hear it too. We're just going to move forward with the sound of the static and it'll be okay. All right, so with that, we're going to go ahead and start with House Bill 212, expungement for restoration of rights. Representative Provenza, welcome to Senate Judiciary Committee this morning. Thanks for being here. I know we had your bill up on Wednesday and laid it over to this morning. So the floor is yours.
Thank you, Madam Chairwoman, and thank you, Senate Judiciary, for hearing House Bill 212 today. I bring this bill to you as kind of a love child between House Bill 140 and House Bill 212. The two bills were focused on reducing the wait time that felons and people convicted of misdemeanors had to wait to have their records expunged. And really, I bring this bill because in my background, I know that through Department of Justice, 82% of people who were formerly incarcerated and who exit prisons are arrested during a 9-year period. They are arrested in the first 3 years. So most people who are going to kind of fail to re-enter society do so more early on, and that's it within the first 3 years after they leave incarceration. So what this bill is trying to do is allow for people to have more access to employment, to housing, and we know that those are the two largest predictors, the greatest predictors of whether someone can successfully re-enter society. So can they get a gainful employment? And this is after they have finished all of their time, if they have probation, if they have fines and fees, they've had to have paid those, that's when that clock starts. So currently under expungement, which is just a seal of your records, it's not a destroying or shredding. The criminal justice system still have access to those, but they are sealed for employers and so forth. So currently you have to wait 10 years if you're a felon. Oftentimes that's 10 years after they finish, maybe 5 years probation, or they've paid all their fines and fees. So some folks look at waiting maybe 20, 30 years before they can even petition a judge. And then for misdemeanors, they're currently looking at 5. And so this would just reduce that to 3. And that is essentially the only thing in the bill, is just reducing that wait time to kind of hope that we can get folks more rehabilitated and get their voting rights back, get their gun rights back, and ensure that they can successfully stay out of the criminal justice system. And so on 212 on page 1, you see that lines 11 through 14 are the changes for misdemeanors from 5 to 3. So 1501 deals exclusively with misdemeanors. On page 2, lines 1 through 4, subsection A, this outlines the limitations of who can seek a misdemeanor expungement. And then on lines 6 through 11, this is changing it from 5 to 3, and this is for status offenses. So these are adult offenses. And then 13 through 15, nonviolent felony convictions. So that's the important point of this, is we're not changing any of what those felonies are. They are currently in the law, and they just are waiting 10 years. And then on the last page, you'll see that the important line here is just line 1, that changes that waiting period from 10 to 5. And so I'll stand for any questions, but that's.
Thank you, Representative Provenza. Just Representative Provenza, for some clarity for the committee and for the public who may be watching, I see that on page 2, line 6 through 12, there's a reference to at least 3, what is originally in statute, at least 5 years have passed for non-status offenses, and at least 1 year has passed for status offenses. Can you help us understand the difference between status and a non-status offense?
A status offense relies on if someone's age, so the understanding of if you have maybe purchased cigarettes when you're 17 years old or alcohol when you're 19.
Questions for the representative? Senator Kolb.
Thank you, Madam Chairman. Representative, I had a question about the way you phrased the word expungement. Particularly, that record is not available absolutely to the courts or to any attorney. Yeah, it may be sealed. I read the definition, but it is not accessible. So I think to make the representation that someone would know this in the future, say if you reoffend, I think it wouldn't be very true. I think that it's sealed and no one knows it. So on the next offense, let's say, right, there wouldn't be any record of said past offense that would be brought up in court or used against you anymore. It's gone. I am for people getting a second chance. I do believe that. I'm just confused on why it should be changed from 10 years to something less than 10 years. You actually get a chance to make your record clean, and I think the state of Wyoming has really gone above and beyond what was in the past. And we have an avenue for folks to clear their record, which I think is great. I do, but I wonder about the time frame. I just don't. I haven't heard a justified reason why I would be agreeable to lowering that. Heard a lot of different comments back and forth. I've yet to be convinced. I'm still listening, but I just don't know the need. So I guess if you could answer that, maybe if you could add more light to that.
Representative.
Thank you, Madam Chairwoman. The reason that I'm looking to change and reduce that time frame is it's twofold essentially. The evidence states that oftentimes people, if they're going to reoffend, it's within that 3 to 5 year time frame. That's in the United States Department of Justice. So it's more likely that if they're going to reoffend, it's going to be during that time, earlier on, not 10 years out. The other thing that I believe this joint committee has heard in the 2018 interim was that it was specific to probation, but the idea can still be applied if you have too much time of being punitive after someone has kind of gone through all the hoops that they need. It makes it more likely that they're going to reoffend if they have to keep kind of jumping through those hoops. And so some of the recommendations that CSG made to this committee in the interim was to kind of reduce the time of those penalties. I mean, I think that logic can be applied here, because if you can't get employment, right? So you keep failing a background check, you can't get a job other than maybe minimum wage. You might be more likely, and the evidence suggests that you are more likely to enter a criminal way of trying to make money, because you have to eat, you have to survive. And so if you're at gainful employment, then you're more likely to recidivate. And so this is trying to kind of reduce that time so that, one, we know that this person is rehabilitated. They've done everything. If the time frame is gone, statistically they're not as likely to recidivate. But we also aren't barring them from being able to access housing and gainful employment.
Follow-up, Senator Kolb. I see.
Thank you, Madam Chairwoman. Well, I'm a little more confused than ever. Now we've got a situation where if we don't give them a shorter time of expungement and their probationary period being over with, that we're going to make criminals. Well, I guess they're a criminal then. If you're going to not have that way of life, I just think it's a great thing that we have an expungement process. I mean, I don't know if a lot of folks understand what this really does mean. I mean, I know you do, but it's a great process. So I still don't get it. You can't have it both ways, frankly. If we're going to argue that you need to shorten it because maybe it makes more sense to say they're going to reoffend, be criminals again, well, come on. I'm confused on that line of logic. But I understand it's, I just was looking for maybe some more clarity on, yeah, I get it. I understand your point, but I don't understand. It tells me to lower it because you're telling me they're going to be a criminal. Well, I would immediately think, well, if you're going to be a criminal, then you do need to wait 10 years. That's what it takes, and that's what it takes for you to be clean or not to reoffend, right? So I'm still listening, but thank you.
Senator French?
Yes, Madam Chair, Representative, you said this would apply to non-violent felonies on the felonies end. Here's some examples of non-violent felonies.
Madam Chairwoman, so nonviolent felonies could be something like could be felony theft. So stealing an iPhone that this is worth more than $1,000, right? And certainly there are other maybe drug offenses that could be seen that are nonviolent felonies, but they're not. Wouldn't be anything such as murder or sexual assault and things of that nature.
Representative, there is prohibitions subject to expungement. The statute is written in a way just to make life difficult for lawyers by providing a long list of statutory references of crimes and offenses that are not eligible for expungement. Do you have that list? Did you go through and pull up all those statutory references?
Thank you, Madam Chairwoman. When I was drafting and looking at this language, I did not bring all of that language with me, but I would agree that it's kind of a double negative of trying to say you can get expungement, but not in these cases rather than, yeah, I would say that it is a little unclear sometimes.
Is that document helpful to answering that question?
Thank you, Madam Chairwoman. I do not. So, okay, yeah, maybe I'm. The list is here. I'm not. I haven't seen this document now, so you'll bear with me.
Like, I think Representative Provenza is quickly reviewing this document. We have the same one. It does not provide an explanation of the list of offenses. It is the statute, but it does not track through what offenses are actually eligible for expungement. So that's okay. Further questions for the representative? All right, seeing none, Representative Provenza, thank you so much. All right, public comment on this bill. Is there anyone on Zoom who'd like to speak to the bill? You could raise your hand. Mr. Barron, welcome. Mr. Barron, welcome to the Senate Judiciary this morning. Good to have you again this morning. You can introduce yourself to the committee and share with us your thoughts on the bill.
My name is Joseph Barron. I'm the Cook County Attorney.
You're muted, Mr. Barron, and it might be us or it might be you. It looks like your audio is on, but it could be our technical challenges here. So hold on just a second.
Mr. Barron, I can hear you on the Zoom. So we've been having some technical difficulties in the room.
Yeah, it sounds like somebody's shuffling papers is what I hear.
We have you now, Mr. Barron. Thank you. We can hear you.
Okay.
All right, welcome. Introduce yourself and share with us your thoughts.
Thank you, Madam Chairman. My name is Joe Barron. I'm Cook County Attorney. I'm here on behalf of the Wyoming County Attorneys Association. I sent out a written statement to the committee last night expressing our opposition to this particular bill. And I'd just like to say go through the process a little bit here. And so what we're talking about here is an expungement. This is the very end of the process. And for somebody to get to the point of having an expungement, they have had gone through the entire process of being allowed to have second chances from everything that I've listed out there in that particular document, from law enforcement's giving warnings, from schools doing things, from diversion programs in county attorney's offices and elsewhere, juvenile court having been not granted a deferral under for drug offenses, 35-7, 1037, 713, 301s for most non-violent offenses, and 720-103 for domestic violence offenses. And then just so there's all these second chances that are already a person has the opportunity to receive through this process. Then the legislature here has voting rights are automatically restored for a first offender on this. The other thing that one of the concerns raised was the term that currently exists is from 10 years for felonies and 5 years for misdemeanors, is to pull that back to 3 and 5. First of all, with regard to that, what I can tell you about that, since recently here in 2019, or I think it was 2019, is you rolled back the maximum allowed for probation is 3 years, and unless the court sets forth specific findings otherwise. And so where in the past we were normally getting, in my experience, 5 to 10 years of supervised probation, we're now almost every order, no matter what it is a 3 years of supervised probation after, if there's any incarceration, unless they go to the penitentiary, and then then they become under parole. And so these long time frames that we are used to see are going forward are going to be shortened up in that matter. So with that in mind, what the concern is that they haven't had enough time. We're going to be shortening the time considerably. Rather than 10 years after they're off of probation for a felony, it'll now be 5. And that could have been like 15 years before, 15 to 20 years before. Now we're looking at 13 years or 8 years if this is adopted. And the other thing that, just as a practical matter from our point of view and victim impact, is that victims, when you have to go back and tell them that they're going to get an expungement, and they tell you, you mean everything we did? All these rights are set up for defendants, and there's nothing there for me, and then they have to relive this. 3 years and 5 years is just too soon. People obviously are more, they're more forgiving and willing to accept the fact that a person has changed on that. And a victim doesn't have, any kind of veto authority or anything like that. We have to contact them, and then they have to relive this. And from my personal experience, it's a lot easier to do this 10 years down the road than it is 3 or 5 years. And 3 years on the misdemeanor is usually the case of domestic violence. That's the only cases I've ever had in misdemeanor court where somebody has asked for an expungement, or previous domestic violence convictions on that. And so that's something that we have. The other thing that I asked for the committee to look at is kind of the standard of proof. I was involved in one of these here, it's been a week or two ago, And the judge struggled with the fact that the standard there set forth in G of this, both statutes are pretty much identical, where the petitioner does not represent a substantial danger to himself, identifiable victim, or society. And so I think there needs to be something there so the judge can look at that, and it's like, can you look at all these other things that are out there? And I think it needs to be made clear that this particular person that's petitioning for this has not had any other convictions since being sentenced for the offense that he's or she's trying to get expunged, and except for like bondable offenses. The way I do that as a practical matter, when somebody files a petition, hopefully they call me ahead of time, which some do, and they say, hey, we're going to do this. Will you consent to this or not? And the process that I have, of course, is contact victims if there are any. If it's a drug crime, let's say, then I contact a law enforcement agency that was involved with a particular case and talk to the officer involved. And we look at that. We run criminal histories. We run YC just to check and see if there's anything that he does, in fact, have a clean record since that time, although it doesn't really say that in the standard there. But you look at those things to see what your recommendation is going to be from the state on that. And, I have one right now where the defendant's attorney in the case will be putting in there that the state has no objection to this particular expungement because it truly looks like, other than a couple minor traffic tickets, and that's why I put in there except bondable offenses, because it's a couple tickets. That's not a big deal. And so, but in another case I had with a domestic violence conviction back in 2012, he was eligible 5 years after 2013, and they just filed that. I just heard this here in the last month. He had had 3 convictions since that time, one for a DUI with a child in the vehicle and one for a child endangering, just got out of probation in 19. And obviously I objected to that. I thought that he was still a risk to society. It wasn't the same identifiable victim that was in the domestic violence case. It was, frankly, it was his daughter and the other people the rest of us driving up and down the highway. And so, but the judge kind of struggled with that to try and figure out this, let's look at this standard of granting this. And the last thing I want to say is this expungement right is a fairly recent phenomena. It's initially came out in 2004 for misdemeanors and 2011 for felonies. And I find it interesting. We have this expungement statute, and then even in our court advisements, the advisements from the court, it says that the only one that can that restore your rights is the governor. But this right has been granted by the legislature and to do so. But I think it's a good right to have, the ability to have, if one has truly changed their ways. Thank you. I'd stand for any questions.
Thank you, Mr. Barron. Any questions for Mr. Barron? Mr. Barron, I noticed in the handout that you provided to the committee, one of the concerns that you identified was the ability to really protect the community, society, particularly as it relates to employment, background checks, daycare facility background checks, those types of situations where a person's history is relevant to the occupation they may be pursuing. Can you very briefly speak to that at all?
Madam Chairman, if this record is expunged, if somebody tries to run a criminal history, and one must understand that our criminal records are limited in scope access on that. They would not, an employer for somebody that deals in money, let's say a bank, or I won't say a bank, but a business that does it, they wouldn't be able to find this criminal record because it would have been expunged.
All right, thank you, Mr. Barron. Stay close as always, Mr. Barron. We're working through the bill. All
Thank
right,
you.
with that, we'll go to additional public comment. Is there anyone else on Zoom who'd like to speak to the bill? If you could raise your hand now. All right, those in the room, if you would like to come forward. Welcome. I think former Senator Jennings, is that right? Welcome, Senator Jennings. Good to see you here this morning. Well, you can have a seat and make yourself comfortable. So introduce yourself to the committee and please share your thoughts.
My name is Kit Jennings and I live in Casper, Wyoming, and I'm here as a citizen that's concerned about the expungement. The handout you saw earlier is the one I gave you. And when when the bill was over on the other side of the building, the merger of the two buildings actually took one bill from 1 year in Bentonville and Midwest. That was where my interest was. So I'm not going to. If you look at the handout that I gave you, I went back and highlighted several pieces of the current legislation. Basically, to give the committee the feel for what it takes to go through what's in statute. Time clock starts when the felon has completed all of his court orders, whatever. You could have the drug case, it could be drug rehab. If it was a probation, might start out as supervised, end up as unsupervised. It could be a fine, and there could be some kind of a payback that was heard in it. I would like to point out in paragraph G, because this was a question from the committee, but in statute now, if the court finds the petitioner is eligible for relief under this section, and that the petitioner does not represent a substantial danger to himself, any identifiable victim of society, it shall issue an order granting expungement of the applicable record. The court shall also place the court files under seal, available for inspection by order of that court. So what this does is that it basically takes the felony off of the person's record, but it does not limit the court from not going back and looking at it if there needs to be a reason. I'd like to kind of skip to the end here and put together a description of a young man that in his, I read statutes, I've talked to people, and this is kind of an average offender on a non-violent drug-related case. If we start out with our 20-year-old West from Wyoming, travels down to Colorado, legally purchases 17 ounces of marijuana and marijuana products, I guess candies, all that kind of stuff you can buy down there too. As our 20-year-old is stopped in Wyoming, his vehicle searched, the state trooper finds the 17 ounces. Obviously, he's going to charge this young man. Now, if the young man has known the law, he would, and only at transporting less than 3 ounces, would only be a misdemeanor. But of course, when young people like this go forward and do things that are not very smart, you always go back to educators and scientists when they're talking about young people. They only are developed when they get about 25. So our young man here, 20, hasn't fully processed all of the stuff in his brain to have when he's an adult to come up with this. Now, when my children used that school that did that, I didn't buy it, but it is out there and it is something that people have looked at. So our 20-year-old is arrested, and he starts his lengthy process through the judicial system. And at 21, he's in court. District attorney has convinced him that if he doesn't plead down, he doesn't plead guilty, that he's going to go to jail and all this kind of stuff. So he agrees to plead guilty, and they expedite the court. And the court tells our 21-year-old to complete a drug rehab program. He fulfill 5 years of supervised probation and pay a $5,000 fine. Could have been $10,000. 5 years later, our now 26-year-old nonviolent felon has completed the court-ordered drug rehab at a cost to him of over $2,000, and I've heard it's even higher than that, depending on how many sessions you have to go to, and has successfully fulfilled all 5 years of probation. However, due to the designation of felon on his record, he's not been able to keep a job that pays more than minimum wage. Therefore, he's only been able to pay about $2,000 and a $5,000 fine. Remember that the drug rehab costs came out of his pocket for $2,000. Now our 26-year-old is now 28 years old, and he's finally paid off the last of the $5,000 fine, therefore completing the requirements of the court. Now, in our statute, at this point, statute 13, 15, 21, A and I begins the 10-year add-on sentence where he can petition the court. Finally, 10 years later, our 38-year-old felon has completed all the requirements of the court, and the additional 10-year waiting period the state required to apply for expungement. He has been saving what little money he could over the years from the low-paying jobs available to him. He has saved a little over $2,000 to hire an attorney to prepare a motion to the court petition. His attorney files the motion and pays the $300 fee. For the last 18 years, our felon has been turned down for basic unemployment, has been unable to establish credit score, turned down for 2 college loans, was refused several places to rent for housing, and was denied an opportunity to buy it. This happened because he made a mistake. In the county that the felon was prosecuted, the prosecuting attorney has to be notified. It's just not, you're not just going to fill out the form and turn it in. If you go back to the statute, you can see that there's a period of time there that the prosecuting attorney has to look at this. There's a period of time there that the judge can look at it. There's a period of decision there whether it can really be taken forward or not. But let's say that all of that, those time periods were used. And in this particular county, the prosecuting attorney routinely objects to all. He believes that this is a necessary thing, and it's done. So,
Theoretical scenario, or are you speaking of a particular county and a particular county attorney?
have some factors.
I'll make you say the name of the county attorney if there is one.
Oh, there isn't one.
Okay.
But this is something that could happen. Actually, the prosecuting attorney asked for a hearing. At the hearing requested by him, 18 years of our felon's life was reviewed by the prosecuting attorney. He determined that our felon was a deadbeat and could not keep a decent paying job. He get himself educated, did not own a house, and never had credit in his name. In other words, poor candidate was during his 18 years of punishment, our felon worked hard to pay his bills, stay out of trouble, and be the citizen that we expected of him to be. But the prosecuting attorney needed about 15 minutes to convince the judge that this man was and always will be a threat to himself and society. Now, the threat here might just be a financial threat. It doesn't say it has to be a physical threat or any other kind of, it's just a threat. And in this case, my make-believe scenario, the judge said no. Madam Chairman, if I could, I don't know if you before, but I mean, I'm talking, so I would like to reference the debate on Wednesday. I'd like to compliment the chairman. Debate got up about your decisions were made. I admire that. In our Constitution, Article 2, Section 1, powers of the government divided into three. Powers of the government of the state are divided into three state departments: the legislative, executive, and judicial. And no person or collection of persons charged with the exercise of powers properly belonging to one of these departments shall exercise any powers belonging to the legislative has their place where they need to be, judiciary and executive. If you go on and look at another portion of the Constitution in Article 1, Section 15, Penal Code. Penal Code calls on us to be humane. Penal Code shall be framed on the humane principles of reformation and prevention. Now, when we start to look at some of these conditions for expungement, we have to decide as a body of what is it that we're after? Do we after vengeance, retribution exacted for an injury or a wrong? Or we after punishment, infliction or imposition of a penalty as retribution for an offense? We after prevention, is the action of stopping something from happening or arising? Or we after rehabilitation, the action of restoring someone's health to normal life through training and therapy after imprisonment. When the bills were
Mr. Jennings, the law requires us to balance all of those factors, and it's the foundation of our people system in the United States of America. So thank you for that reminder. We are short on time. We've done 45 minutes on this bill. We have 3 other bills to get to this morning. I'm going to ask everyone to wrap it up. Concepts are simple.
I'm wrapping
Representative Provenza, I'm going to close public comment after this, but we're going to be done. Representative Provenza, do you have any final comments? Do you have any data associated with how many of these funds were granted in your state?
Thank you, Madam Chairwoman. Just to be brief, I do not have data in terms of how many. I know that the Attorney General's office testified in the House, and ECI processes about 20, 30 of these requests a month.
A month?
Yes.
30 expungements are granted every month in the state of Wyoming?
Madam Chairwoman, it's not that they are granted. I think that they process, so they go through them. I'm not sure if they are granted or not.
Thank you, Representative Provenza. All right, with that public comment, please. Back to you. Is there a motion on the bill? All right, seeing no motion on the bill. Roll call. No, we don't do a roll call vote. That bill has failed. Thank you, Representative Provenza. All right, with that, we're going to Representative Washit, firearms transactions, financial discrimination. Welcome, Representative Washit, a member of House Judiciary Committee. Welcome to Senate Judiciary Committee. Good to see you this morning.
Good morning, Madam Chair. Glad to
Representative
be here.
Washit, you're aware that we're short on time.
I will be expeditious in my description of the bill. There are some witnesses waiting in June.
Representative Washit, I note that there are no members of Senate Judiciary Committee as a co-sponsor on your bill. Would you like to speak to that?
Can you repeat that question, please? You're a little soft.
I want Representative Washit if you could walk through the bill for us.
All right. What we have here is House Bill 236. Deals with an increasingly common practice where financial institutions are discriminating against lawful firearms businesses. who are engaged in lawful commerce of firearms. And then financial institutions deny them access to credit card services or credit, not because they have bad financials, but solely because they're engaged in the business of firearms accessories. A couple things I'd like to point out is in the bill, you see on page 2, you go into definitions, identifying all the key elements of, ammunition and so forth. But it also lists 4 ways in which discrimination can occur. A, on line 13, refuse to engage in the trade of any goods or services. B, refrain from continuing an existing business relationship. C, terminate an existing business relationship. Or D, otherwise unlawfully discriminate. So what we're talking about here are financial institutions outside of Wyoming. All of the witnesses that you're probably going to hear from today are going to tell you about a good working relationship with Wyoming financial institutions. Where we have problems is when pressure comes from outside. So when pressure comes from outside and tries to influence these types of business decisions within the state of Wyoming, affecting our Wyoming business. So we talked about 3 different types of firearms entities on page 4. These are a firearm with firearm accessory, ammunition manufacturer, retailer, distributor, a shooting range, or a trade association affiliated with the firearms industry. The meat of the bill occurs on page 5, where we say a financial institution shall not discriminate against a firearm entity because the firearm entity supports or is engaged in the lawful commerce of firearms accessories, or ammunition products. An important part in section B on line 14, this section does not apply to a financial institution that chooses not to provide services to a firearms entity for a legitimate business reason or due to a directive by a regulator. For the purposes of this subject, the business reason does not include a generalized policy refusing to provide financial services or otherwise discriminating when providing financial services to a firearm entity. Page 6, we get into the remedies. There are 2 remedies spelled out. Subsection A, a civil action. Court of competent jurisdiction shall award the successful party reasonable attorney's fees and costs, and the court may award the successful party any of the following at the court's discretion. Line 11, actual or compensatory damage. Line 13, treble damage. Line 15, punitive or exemplary damage. Line 17, injunctive relief. Line 19, any other appropriate civil relief. Then on line 21, the Attorney General may, for discretion, file a civil action for violation of this article. The Attorney General may request the court to do any of the following, which is lined out on page 7. Declaratory judgment, enjoin an act or practice in cases of repeated discrimination, failure to follow one's own financial institution's anti-discrimination policy, impose a civil penalty. The Attorney General, if the Attorney General prevails on an action, this is line 16, a court's order for relief, in addition to any other remedies, may include relief sought under subsection B and include an award for reasonable attorney fees and investigative costs. And on the last page 8, the Attorney General shall submit, this is the only shall here, the Attorney General shall submit the name of any financial institution that has violated this article to the governor and request that the state terminate any business relationship with that financial institution. And that's so I just want to conclude my comments by saying the state of Wyoming has done a great deal to diversify its economy, trying to lure financial firearms and firearms related industries to Wyoming. And Both worked in this direction. We've been very successful. We brought in some major players, and you've received letters in your email box from some of those companies supporting this legislation. The reason some of those companies came to Wyoming is because they were looking for a more hospitable climate, policies that are conducive to the firearms industry. With that, I'll stand for questions and encourage you to bring in the Zoom more.
Watch it on page 6, line 13. Can you identify for me what trouble damages are?
My understanding that would be a tripling of actual.
Representative Washit, good job. Thank you. What about punitive and exemplary damages?
Punitive damages are punished, each nonetheless, and set an example for others to serve similar conduct from other people who might be inclined to do.
Representative Washit, this bill, this concept reminds me of concerns regarding some of our other state, large financial institutions in this state and their global positions on fossil fuels. Have you been reminded of that conversation or those concerns and any thoughts about that?
Yes, Madam Chairman, we certainly have heard those concerns from financial using to support fossil fuel industries. I've even heard of some that were talking about animal products, from a more vegetarian animal rights kind of perspective. So it's basically the cancel culture comes to financial.
Or Representative Washit, it's the capitalism that comes from financial institutions, where the consumers and their shareholders make a decision about the type of companies they want to support. Representative Washit.
Thank you, Madam Chair. Yes, banks and financial institutions are a little different than your average business that gets to decide, anybody that walks through the door that wants to buy my product. Banks, financial institutions often are the repositories of large sums of public money. They have been bailed out by the government not too many years ago. These major banks were, supported by our government. Many of them have a little sticker on the front door that says they're federally insured. And that, to me, changes the relationship. They have a public responsibility, especially when it comes to a constitutionally shielded business enterprise like firearms. Right? You have the Second Amendment, we have Article 1, Section 24 of the Wyoming Constitution. These businesses are different than their shoes.
Representative Washit, we are for-profit businesses, right?
You certainly do have shareholders, but I think you have a broader responsibility to the society at large.
Any questions for the representative? Thank you, Representative. Mr. Cole, we have you on Zoom. If you could start your camera, we'd love to hear from you. I know this is important to your industry. You're in the room here with us live. If you could raise your hand, please, and speak on this. Mr. Cole, if you could start your camera. If you're online and on Zoom, if you also intend to speak on this bill, if you could raise your hand. Welcome, Mr. Cole. We are experiencing some technical difficulties, so we might have a little bit of a hiccup here. If you could speak for us and just introduce yourself. Looks like he's frozen. Mr. Cole, we will come back to you. Mr. Larson? All right, Mr. Cole, if you could speak for us. Could you say your name, Mr. Cole? We still have you muted. Mr. Cole, we'll come back around to you. We're going to go to the folks in the waiting room or here in the room with us live as we work out some of these technical difficulties. Judy, we might want to get Jamie back or someone, as we have two folks on Zoom to be ready to facilitate their public comment. So with that, we'll go to Mr. Faulkner. Commissioner Faulkner, welcome. If you would come up.
Madam Chair, thank you. Albert Faulkner, the Banking Commissioner here from the state of Wyoming. With me, our General Counsel, new General Counsel, I might add, Nick Rochadle. Fairly new to our office, but we're definitely getting up to speed quickly. I will apologize that we came to be aware of this bill late in the game. It was most of the way through the other house before we had that out there in the legislative world. So we're playing a little catch up. As you know, Madam Chair, that as a commissioner, I'm the administrator of Title 13, which includes banks and trust companies, and then we have a host of non-bank laws which we administer as well. So my comments today are really going to be more about how we would administer it. A number of questions that are raised here, not the idea itself is a good idea or bad idea, and it's really about there's some things that are in conflict with things I think our existing statute in Title 13, and I'm not even sure what conflicts might exist regarding federal banking. So that's why I'll highlight a couple points. Question I had is on page 3 regarding the definition of financial institution. 13.1.101 already has a definition of financial institution. This one is different than that. A couple things. The definition includes payment processor, which is not defined. I'm not quite sure what we're talking about. I think if you're going to include that, there needs to be some clarification of what we're actually talking about. Processors, there do they not? Hard network processors. The other part of that definition, two other items. So the last item says for credit unions. So, charters, and then there's a federal or national charter. Credit unions are the same way. There are state and national charters. Wyoming does not have a state charter. We don't have the authority and statute. So here it would be national charter credit unions. And I'll get back to it in a second because it ties into the other question. So we have talk about financial institution includes the term bank. 13, definition of bank does not include a national bank. And so what you have here is this statute only applies to and the national banks have law. And so this would be the 25 state charter banks which we oversee. So just wanted to highlight that. Here's a little bit of for an extra burden on our Wyoming institutions. And Madam Chair, I think you've known and heard from me enough that just a staunch protector of the Wyoming charter. I think it's a valuable charter, and I just
Commissioner Faulkner, on that topic, to your counsel, question here, do you think that this is unconstitutional as a result of the disparity between treating national banks versus state banks, putting a higher burden on state banks, interfering with equal protection clause, those types of issues with common clause issues?
Thank you, Madam Chairman. Thank you, Senators. Pleasure to be in front of you. Just to introduce myself and then I'll answer your question. My name is Nick Rochadle. As Commissioner said, I am the General Counsel for Banking. And I look forward to working with all of you on the different issues. To your question, I think where the issue is that generally national.
I see the other lawyer in the room escaping right now. He knows I'll call on him randomly.
The issue is that if a state law substantially interferes with a national bank's power, a national bank's exercise of power, the national bank, their powers um, will override the state law. So if you have a state law here that is contrary to a national bank power, you're not really going to be able to enforce it against a national bank.
That derives from the supremacy clause.
In part, yeah.
I'm familiar with that this session. All right, some thoughts for you to consider too is those equal protection issues. Because we deal with this a lot when we make two different classes of business entities or people. One in-state, one out-of-state, or other types of separations of classes, and we treat them differently. It always triggers that, and I haven't thought much about it either on the legal front, but letting that seed in your mind for further discussion for all the stakeholders involved, if that's a concern. Those that care about the bill want it to be constitutional, and want it to be effective for its purpose. So recognizing that concern is intended to remedy those issues. Back to you, Mr. Portman.
Thank you, Madam Chair. Yeah, and then that these issues not specific to the topic here exist and have existed, and just difference between the state and so we've dealt with a number of those. The whole idea of discriminating against an industry as a whole. States don't like that. I served as chairman of the state association a few years back, and we came out and made a statement against basically the concept of Operation Choke Point, which was one that deemed to regulators push out what they would deem to be unsavory, not politically correct, their exercise of probably questionable means, but that was done mostly at the national level. And so very aware of that. Money transmitters faced the same issue about 10 years ago. So to that point, I just want to highlight that we get that. I will say on page 5, it talks about on line 16 going into 17, due to directive by a regulator. Yeah, I think that if we're going to have that language, it needs to be clarified. Everywhere else throughout the statute, it talks about the commissioner, or it talks about federal financial regulator, out-of-state regulators, things of that nature. So there would need to be, because that term is very broad, and there's all kinds of regulators out there. And then moving on to the next page 6, violations of law. Banks violate statute more frequently than you would think, and it's often just some sort of oversight. Something didn't get the proper documentation in the file to say, yes, the board approved this per the statutory requirement. We highlight that. If it's systemic, it impacts the bank's rating. We can spend an hour talking about how we rate banks, but banks are assessed, and depending upon the rating, there can be enforcement actions taken by a regulator. Most actions that occur, the public never knows about because they are confidential between the institution and the regulatory authority. So violations of law are highlighted in our report of examination. The report of examination is that of the property of the state of Wyoming and is protected by confidentiality. So there is no way for anyone to know that a violation has occurred. Here, what as a regulator, what makes me a little uncomfortable here is it feels like it's pushing to do supervision for enforcement, which I am adamantly opposed to as a policy. That's just not good policy, I don't believe. So I tell you that my 23 years with the we have not instituted any fines based on violations of the law. Now there have been certain federal laws that have been violated and done at the federal action or at the federal level, but for the most part, that's just not a practice that we engage in because we give them the opportunity to correct it fairly easily, especially if it's an oversight. Again, if we felt that there was a real problem with the practices, we would address that through some other enforcement actions. The other thing you got to think about is we also have a federal regulator with us. It's either the Federal Reserve, if you're a member bank, or the FDIC. So we have to coordinate between the two agencies on that. So bringing this, where we have the Attorney General making action, while that is, I think, legal, I would assume that this would have to be based upon our referral. and again, I guess I don't know how they, if a complaint is coming to the Attorney General's office, I'm not sure how that works. And so I think that there probably needs to be a little more clarity on what our role would be in that process. Are we the client of the Attorney General? Are we the ones bringing the action? So there's some things that I'm just not quite sure how practically that would work. And then on page 8, again, I guess it would depend upon if actually a legal action took place, but the Attorney General submitting the name of a financial institution that has violated this article and requests that the state terminate business. Again, what are the confidentiality ramifications there? Something that's protected under our statute being made public should not be. And then we have some questions as to terminate business relationship. That really needs to be defined, because one can take that to the extreme. That would mean that we would revoke the charter potentially. That's why we really have to figure out what does that mean. My guess is that it's probably with the public deposits is probably the intent there, that the state will not place public deposits, but again, people would have deposits that have to address that issue as well. So those are just some concerns there. Again, not the for or against that we're not allowed to do that, but I just want to highlight some questions.
Thank you, Commissioner Fortner. Questions for the commissioner? Are you able to hear the commissioner?
I'm coming
All
through
right,
clear
seeing
in
that
my
I-
microphone, but
Seeing that I have a senator admit that he couldn't hear any of the testimony, what we're going to do is we're going to lay this bill back to the meeting, because of the technical concerns associated with the bill. That we can't have you voting on a bill you haven't heard anything on. The bill will be laid back as a result of technical concerns. I'm sorry for those in the room, in the waiting room. Mr. Cole, I think it'll just be laborious as a result of us probably not being able to hear you very well either. On the Zoom situation, and Mr. Larson, you as well. So we do have a noon meeting scheduled on our agenda as well. We're just going to move this bill to that time slot. 15 minutes upon noon recess. Representative Washington. Sorry for this, but I think it's important. Today.
Madam Chairman, that meeting will be in room 6.
It will be in room 6, so right down the hall. That's right. With that, we're going to go to some additional bills here in the room that are blockchain bills that are that have been worked in the interim. Mr. Coffin, please come forward. In the event that any of the committee members cannot hear the testimony at all, I need you to speak up, and so we can get that addressed because it's important that you're able to hear, even though we've got these technical concerns. Mr. Kaufman, welcome. Senator Rothfuss, the chairman of Senate chairman of the blockchain committee, is on his way. But we have in front of us House Bill 41. Which is intrastate crowdfunding exemption amendment. Mr. Kaufman, I'm going to ask you to speak extra loud as well, even though we have microphones, they're clearly not working very well. If you could walk us through the bill, Mr. Kaufman, that would be most helpful. Of note to the committee members, I also serve on this task force, as does President Dockstetter and Majority Leader Westphal. So, Mr. Kaufman, please proceed. Introduce yourself to the committee.
Thank you, Madam Chair, and I'll try to speak loudly. My name is Matt Kaufman. I'm a partner with the law firm of Hathaway & Coons here in Cheyenne. I'm also a governor appointee to the Select Committee, along with Madam Chair and others. To the committee, so the quick background for this bill is whenever a company is raising money from outside investors, that activity is regulated by securities laws. And there are a number of exemptions that exist for companies to legally
Can everyone hear Mr. Kaufman?
Raise that investment capital. The typical way that companies do that, if you're not going to publicly register your stock, like on a stock exchange, you have to find a private placement exemption. A number of those exemptions exist both in federal statute and in state statute. This particular exemption that we're talking about is an exemption that exists within state statute. It was created a number of years ago by you all. It's known publicly as the Wyoming Invest Now program. And what it is a state, an intrastate to be more precise, crowdfunding exemption. Intrastate is an important distinction because in the securities world, if a company is only raising money from within a state's border, you're not engaging in interstate commerce for purposes of constitutional interpretation, and thus the Securities and Exchange Commission doesn't have jurisdiction. Our state Secretary of State's office would have the sole jurisdiction in that case. So this is simply a clarification bill, or I guess it brings some revisions to our state's trust state crowdfunding exemption. So with that, Madam Chair, I'll walk through the bill very quickly. So the first change to this statute is in 17.4203 appearing on page 2. Currently under the WIN program, the intrastate crowdfunding program, a company has 2 tracks they can choose to raise money under this exemption. You can do the small track and raise up to $2 million, or you can do the large track where you raise up to $4 million. To date, in the state of Wyoming, we've only had 2 companies utilize these exemptions. It was something that I brought to the select committee that I thought these exemption limits were a little too low. One of the reasons being that if a company chooses a federal exemption, while there are slightly different requirements, there are very few limits on how much a company can raise. Additionally, federally, we also have federally permitted crowdfunding. And just recently, the SEC notably raised the limits for federal crowdfunding from just over $1 million up to $5 million. So the limits in the securities world are changing, and this is a tool for startup companies or growing companies to use to raise money. And so, I believe it's important to keep these limits in line with changing times. So the first change on page 2 is simply changing that small limit from $2 million up to $3 million, and then on page 3, changing the large limit from $4 million up to $10 million. Madam Chair, the second change, substantive change at the bottom of page 3, in the securities world, again, there's an important definition that often we hear about called an accredited investor. Simply an accredited investor is a higher net worth person. It's someone who makes more than $200,000 a year or has more than $1 million liquid net worth. The policy of the federal statutes are if you're an accredited investor, a company has to give you fewer disclosures. You're a little bit more able to protect yourself, theoretically, from risks in an investment. If you're a non-accredited investor, the disclosure requirements are often heightened, and the policy of the law is to take a little bit more of a protectionist stance towards those investors. In Wyoming, we have defined for purposes of the WIN statute previously that if you're a non-accredited investor, so you're one of those lower net worth people, you could only invest up to $10,000. In my experience in doing a few of these crowdfunding offerings, that's just not very workable for these companies because there's transaction costs with closing every investment deal. And to only accept $10,000, we found a lot of companies just saying, no, that's not worth the time. So this change would raise that limit from $10,000 to $25,000. So non-accredited investors could invest up to $25,000. If you are an accredited investor, you could still invest in the company. And then finally, Madam Chair, the changes on page 4 and page 5, I'll explain very simply. The policy of this statute when we passed it a few years back was that if companies were taking advantage of this crowdfunding offering mechanism, we set up a mechanism where they had to file a quarterly report with the Secretary of State's office regarding what they did with the money, how the company's performing, sort of basic financial data. That sounds great. The problem is if companies use the federal exemptions, you don't have a reporting requirement. This has become a deterrent from people using the State Crowdfunding Act because it creates a burden. It creates an administrative burden. So we simply eliminate that affirmative reporting requirement and change it to companies have still the obligation to maintain that information and keep it on file for any investor that might want to see it. But we're changing it so that there's not an affirmative report that has to be filed with the Secretary of State. Madam Chair, with that, I'll stand for any questions. That's essentially an overview of the bill.
Mr. Coffin. Welcome, Senator Rothfuss. Yeah. We're just going to try to cope with this through. Senator Rothfuss, do you have any additional comments or explanation on the bill? We're running out of time.
In the interest of time, no, I think Mr. Kaufman covered it very well. I'm happy to answer questions.
All right. Any questions for Mr. Kaufman? Or public comment, Commissioner Faulkner, any comments on the bill? Love it. Yes. All right. Secretary of State's office, welcome to see you in the back. Come on up, Ms. James.
Madam Chairman, Senator Kolb actually did have a question.
We'll bring Ms. James up to you here. Senator Kolb, go ahead.
Oh, page 5, line 3. Do you intend to have a semicolon after website, or you want it a period? That's my only question. Thank you.
Mr. Kaufman,
Madam Chair, that appears to be a good catch.
I think it's correct. I think it's correct.
Oh, yeah, no, I stand corrected. You're right. It is correct.
Study it, think about it. We'll come back to you about semicolon. All right.
That's the toughest question I could have expected.
Ms. James.
Madam Chairwoman, Committee, Kelly James, Wyoming Secretary of State, we do oversee securities regulation in Wyoming. We also help to foster capital formation. And we did speak on this bill on the House that the limits were rather high. We are already on the high end compared to other states. We did compromise. There were amendments passed and these limits were lowered, and we are now comfortable with this language and we just
Thank you, Ms. James. Any questions for the Secretary of State's office? Mr. Kaufman, you're good with those changes?
Sure.
All right. Any additional public comment on this bill? All right, seeing none, public comment is closed. Committee. Moved by Senator Kolb, seconded by Senator Koss. Discussion on the bill. Seeing none, roll call vote on the bill.
Aye.
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 Aye. Cooking with gas now, folks. All right. It's been a rough start. With that, we're going to go to House Bill 43, Digital Assets Amendments. Senator Rothfuss. Mr.
Madam
Kaufman,
Chairman,
come on
I'm
up.
going to call up the Division of Banking, have them walk through specifically. In the interest of time, instead of going over it myself, they're all clean up. I want them.
The division, Commissioner, please come forward.
I'm just trying to get you out of your class.
I think we have somewhere to be.
Madam Chair, that's not how I interpret the actions, but
9:30,
passing
Senator
the buck,
Rothfuss.
I think comes to mind.
Use your fast voice.
So, Commissioner, do speak loud. If you
Yeah, I
can.
will. Yeah, it's very interesting. So I feel like I'm yelling here, but obviously you're not hearing me. So I'll just yell nothing that the bankers aren't used to. So I'll just use my regulator voice. We'll call it that. So yeah, Madam Chair, Committee, yeah, this is Senator Rothfuss said this is a continued cleanup. As you know, Wyoming has led the charge. We can speak all morning about how we are well known now around the world on the activities of digital assets. I'm getting contacted by people in and around the country as well as around the world. Wyoming has entered into agreements with regulators outside the U.S. And so what we're doing here is with anything that's new and novel, you catch things as time goes on. And in the digital asset space, not only that, it continues to evolve quickly. And so this here was run through I believe it was a select committee bill, and then sent over, here to Judiciary. I will say that just walk through quickly on the few items here to kind of highlight some of the changes. On page 2, so starting on line 7 through 13, I'm sorry, we're just clarifying language to say that digital assets can only be one of these three. The way it's worded now, it alludes that maybe there could be something else. So it's just a better sentence structure. Page 2, line 21, again, changed to make it more consistent with the UCC wording, which says agreed. So that's just literally clean up there. page 3, so 4 and 5 are, while it's only 2 lines there, that it has potential to have some very good positive impacts. And the idea is that UCC 9 specifies that the state consumer protection law takes precedence over other provisions of Article 9. There's a lot more details to that, but that's the gist of it. And so Wyoming's interest in acting 3429-103 is to entice digital asset companies to take advantage of Wyoming law. This is one more thing because of the when consumer protection aspects are in part of that law, they can take precedence. So it can actually potentially be more attractive here in Wyoming.
So Commissioner Porker, the CPA trumps, is that correct?
That'd be, yes, to some extent. There's a lot of nuances on this. I'm going to elaborate on.
Thank you, Commissioner. Chairman, I'm happy to, Chairwoman, I'm happy to take the question. In Article 9, this section that is referred to here on line 5, 34.19-201B. What that section says, and I'll summarize, is that if there is a consumer protection statute, that statute will trump what's in Article 9. So really all this means, what we're doing here is saying, if there's something in the digital asset law and it's different than what's in Article 9, because the digital asset law is a consumer protection statute, it would take precedence over Article 9.
Madam Chair, moving on, then down the bottom part of the page there, really 15 through 23 is rewording. And then just a brief history, those members that knew our previous general counsel who had come from LSO was the consummate perfectionist. And so he was reworking his own wording. So he had drafted this, he looked at it, he decided that he could write it clearer. And so that's what a lot of these are. And then I would also say that as we've had conversations with law firms around the country, they'll bring questions and say, well, what is exactly you're saying here? Does this mean it that we think we know what we're doing? But and so that again is, I should have said that early on, that's what's prompted a lot of these clarifying changes. Page 4 provides certain exceptions to make it more consistent with the existing UCC. Moving down the page, lines 9 and 10 clarifies that others can be party to a security agreement. Bottom of the page there clarifies the intent of this provision to only apply to existing situations under UCC that would require a financing statement. So there may not be a financing statement required in certain circumstances. On to page 5, clarifies ambiguity that a digital asset must be held for the entire 2-year period without notice of the competing claim before liens are cleansed. And so that was something that Wyoming did, is there's lien cleansing provision in place now because of digital assets. There could be some outstanding liens that holders of digital asset may not know exist as they have been traded and exchanged. And so adds some clarification there. Moving down the page, just adds a statutory reference for clarifying language. You see the same on page 6 is we would deem to be just clarifying language, cleaner reading. Page 7 adds possession to recognize that you can have possession of virtual currency or control securities. Is kind of the distinction between the two of a digital assets, consistent with Wyoming statutes 3429-103. And then page 8 recognizes that you may need to have other terms in the security agreement. Got some room there. And with that, Madam Chair, that is.
Senator Roth, the second.
For the committee's edification, this is the 3rd time we've worked on this, I think, with revision after the first original statute, which was the first of its kind in the country, map digital security, digital assets, and the stewardship thereof to the Uniform Commercial Code. Other states are emulating us, getting a lot of feedback from all over the country and all over the world. It's an about 125, a good little bill sponsored by one Senator Nethercott. And honestly, this is one of the things that has put us on the map, but we keep tweaking it and upgrading it because these UCC code specialists come to us with quirky little problems. And so each year we come with a bill like this to make it better and again, continue to set the gold standard. So that's what we're doing here. I don't think there are any significant policy changes in this one. This is basically all cleanup. I don't think new policies.
Chair, if I can, I'd say this. We have talked to, I think we're up to 11 or 12 states now that have reached out to our office to say, hey, either the bill was brought by one of the legislators or they themselves, their agency is looking at it. So there are carbon copies out there. Some states are closer than others, but again, so I think that's why it's important that we continue to refine this, and I fully expect that, you know, for a few sessions to come, we will continue to have nuances, but making this is clear and important for what Wyoming has done and how we've positioned ourselves. I think these are all seem to be positive changes.
We are seeking perfection.
Nothing else.
Oh, the word. We appreciate that. All right, thank you. Any questions? Senator Kolb.
Thank you, and I will say up front, it won't involve punctuation. So page 3, line 18, I see this word control. There's no definition associated with here. And I'd make a joke about the fractured blockchain. So if someone could expound on that and explain that.
Chairman, Senator Kolb, control is a deep term of art in the Uniform Commercial Code. And so when we say control here, that's one of the key concepts underlying the way we handle digital asset custodianship, where if you have control of it, which basically means that in cryptocurrency or digital assets, it typically means that you've got the keys to it, so to speak. Then you have a possessionary interest. It's your property, and so we lay it out based on if you're in control. There is an alternative approach that was actually the suggestion by the Uniform Law Commission, which allowed for an opportunity of indirect control, and we went a different way, which honestly then was kind of us leading the charge. So it's an important concept, a term of art. It definitely doesn't need to be explicitly defined and is realistically elsewhere, because the Uniform Law Commission, Uniform Commercial Code is built on control concept in many instances.
Commissioner?
If I may, Chairwoman, there is a definition of control in a part of the statute. I don't want to go into too much technical detail. We can dive as far as you want into this. Generally, the concept of control for digital assets is defined in 3 ways. One could have control because they have control of the private key. Private key is like think of it like a password, be able to conduct transactions, transfer the digital asset. That's one way. The second way is through a multi-signature wallet. And all that really means is instead of having one key to control the digital asset, you have 2, 3, or 4. So instead of using one key to transfer the digital asset, you would need to have multiple keys. That's the second way. And then the third way that control is in the statute is the term smart contract. And that is another rabbit hole, and that is separately defined, but it generally is a computer program that you can set up on a blockchain infrastructure in which you can define ways in that smart contract would handle the digital asset, when it would transfer the digital asset, when it would liquidate it. Whoever sets it up can program how that contract will handle the asset. So those are the different ways that control is discussed in the statute.
Thank you. Great question. Any further questions from the committee? Seeing none. Thank you. All right, seeing none, public comment is closed. Committee, back to you. Moved by Senator Kloss, seconded by Senator Kolb. Discussion on the bill? Right, Val? In perfection? Question being called, roll call vote on the bill. Senator Cooper?
Aye.
Senator France?
Aye.
Senator Cole?
Aye.
Senator Cross?
Aye.
Chairman Nethercott. Madam Chairman, House Bill 43 passes with 5 ayes.